Can you answer that, Councilman Chism first?
Yes, Your Honor. Your Honor, my concern at this point is not disclosure. My concern is twofold. First of all, when this data was requested by the defense and when the Commonwealth agreed to the request, it was in a spirit of fairness because the Commonwealth expert had received the raw data from defense testing, and so clearly the Commonwealth was not going to object to Dr. Dudley or whoever the defense selected receiving the raw data from Dr. Hebben and Dr. Casey. Certainly the Commonwealth had no understanding that it would then be turned over to counsel for purposes of cross-examination. And the additional issue that Dr. Hebben has now raised is that she is very concerned, although she will obviously do whatever the court orders her to do, but this testing is proprietary. This testing is valid because the questions are not known to the subjects ahead of time. And if what Ms. Regan proposes to do is read the questions into the record, and then presumably the defendant's responses, which raises a different issue, she is very concerned that that will put on the record the questions for these tests and raise the possibility of invalidating them. As I indicated, she will obviously respectfully do whatever the court orders her to do, but this is an issue that obviously goes beyond my complete understanding, and I'd be happy to have you hear from Dr. Hebben, but it was not an issue I could anticipate because we didn't, in fact, receive the raw data.
Okay. Ms. Regan?
I assume the Commonwealth had the raw data because these are their witnesses. The reports were exchanged. They had reports talking about the data. The defense filed nothing to keep this raw data from tests performed by their experts secret. The raw data was there. I received it in an email to me, not from the Commonwealth experts, but I received it in an email to me, and of course I looked at it, and of course it forms the basis of my cross-examination. The Commonwealth is relying on these tests. I'm allowed to explore it. I haven't kept anything from anyone. This is stuff produced by the Commonwealth's own experts.
Okay. Well, the first thing is, and I don't have handwrite right in front of me this moment, but the first thing is that when raw data is requested by a Commonwealth expert, or raw data goes to a defendant's expert, the raw data doesn't go to the Commonwealth. That's the whole protection that is central to the whole same records rule procedure of handwriting. I'm not going to get into a long discussion about it because of the limitations of time, and I didn't come out here prepared to address it. But in its most stark, simple terms, it's not fair for the Commonwealth's expert not to have the same records as the defendant's expert, but that doesn't mean that the prosecutor can have it. There has to be a procedure before the prosecutor can have it. So that's number one. Number two is we are stuck right now in a catch-22. That's what it is. It's a catch-22 because the defendant is saying that this raw data is necessary to cross-examine. That means it's going to include statements of the defendant. Now, whenever that happens, you always need to duck on redirect, but that's for the defendant to decide, not the court, whether the defendant's going to open up statements of the defendant on cross-examination. But if the statements of the defendant are going to come out and the concern of the Commonwealth is they couldn't prepare for cross-examination, that I have a solution for. It's not a good one, it's a terrible one, but I have a solution for it, which is that they have the time they need to prepare. Now, it's a bad solution, which means that two things can happen. And one of them I'm not going to do over the Commonwealth's objection, which is that Dr. Crenshaw comes in out of order, which makes the testimony convoluted, and I certainly am not going to do that over the Commonwealth's objection. The second option is, but that's the second option. The first issue is that the Commonwealth can have the time that it wants to review, and with all the unfortunate implications of that for jury time, but the most important thing here, as precious as jury time is a fair trial. The second option, as I said, which I'm not going to in any way, even if Mass Evidence Guide 611A allowed it, require witnesses be taken out of order. And the third problem is that if the Commonwealth, despite not having enough time with the raw data, wants to, for whatever reason it might be, concern for jury time, putting in the case with narrative richness and continuity, or whatever time it might be, reason it might be, it wants to go forward with its hands tied behind its back, then that solves that problem, but doesn't eliminate the third problem, which is this requires the Commonwealth to have seen this so they could file a motion to impound and that the court could consider how to deal with the cross-examination that would be exposing on television and to the world raw data that will compromise the mental health treatment of hundreds of thousands of people. So if we can get through obstacle one, and obstacle two, we still have obstacle three that the court is forced to deal with, not with a decision that satisfies Commonwealth versus Cohen as it relates to closed courtroom issues, but with a decision in the posture that we're in right now. So that's where we are. So as it relates to the issues of cross-examination, what type of questions, without getting into the, well, first of all, let me start with the Commonwealth. Is the Commonwealth requesting to recess for the day or not?
No.
So what type of questions would you be asking on cross-examination as it relates to concerns about compromising serious issues concerning testing that's used, the MFAS test, the Sears test, and other tests that have been used as you get into the raw data?
With the MFAS, I intend to offer into evidence the interview booklet and to question about the defendant's answers. It can be marked for identification.
I would ask that it not be. My understanding is whoever gave it to them shouldn't have even given it to them. It's so proprietary.
Well, that happened nonetheless.
So
Okay.
I'm asking that it not be marked for ID at least by
Yeah,
exacerbating.
no. Okay, yeah, all right, yes.
And then as far as the Sears goes, there are some questions that I intend to ask about.
All right, well, I need to know the implications of the questions. I need to know what the questions are in order to make incredibly delicate decisions relative to cross-examination, not by taking the 6 months or so that the Supreme Judicial Court would have to analyze it, but with the jury in the other room and 2 experts waiting as well. So what's the nature, I guess what I need to do is have the nature of the cross-examination so that I can do an analysis of this.
Well, on the MFAS, the expert based her decision on scores on something called reported observed symptoms. And that is actually, there's only 3 questions for reported observed symptoms on this test. And the questions, as I would assert, show that they are not very revealing, and to some extent they are silly, and it undercuts her credibility. As to extreme symptoms, I would ask about the 1, 2, 3, 4 questions that he answered and what they were, what the extreme symptoms were. As to unusual hallucinations, I would go through all 5 questions and show show which ones he answered yes to, and I would also bring out what psychiatric symptoms he denied having on the MFAS. I would also bring out, there's a trick in the MFAS. In the beginning, the test giver says, do you have ringing in your ears? And if the person says yes, they say, well, you know, sometimes people with severe mental illness have ringing in their ears during this test. And at the end, the test giver says, did you have ringing in your ears during the test? And then they use that against the defendant as being...
Let me ask you this question, Ms. Regan. As it relates to the cross-examination, and this would require a colloquy with the defendant, as it relates to the cross-examination, are you willing to waive the defendant's Sixth Amendment right to a open courtroom?
Yes.
Okay. All right, I need to make partial closure findings as to the First Amendment issues, but I need a proffer from the doctor first to be able to have those grounds. So why don't we call her in, if we could, please. Yes. What I'm doing, I hope is clear. This is a box that, until I thought of that, this very moment had no solution. Having thought of it this very moment, I guess I can figure a way out of the catch-22 without the 6 months that the appellate courts would have to analyze it. So why don't you speak to her, tell her why I'm asking questions, and I will come back out in a couple of minutes and see if I can make First Amendment findings or not. All right, court will be in recess.